I'm Judith Sadler, attorney in charge of the Energy Corridor Office of Holmes, Diggs & Eames. If you're like most companies and employers, you want to keep your company information confidential. I'm often asked by employers what steps can be taken to prevent employees from disclosing information that they consider confidential and proprietary. One step is that employers can have employees sign a confidentiality agreement. What is a confidentiality agreement? A confidentiality agreement is an agreement that the employee signs stating that the employee will not disclose information belonging to the employer that the employer considers confidential and proprietary. Can employers require employees to sign these agreements? The answer is yes. Employers can require employees to sign these agreements as a condition of being employed. Usually the agreement is signed at the time the employee is hired, but it can be signed at a later point in the employment relationship. I'm also often asked if these confidentiality agreements are enforceable. The answer is, again, yes. The agreements, if properly written, are enforceable. However, the agreement must not be overly broad and cannot restrict an employee's rights under federal law. Employers need to remember that if an agreement is overly broad and unlawfully restricts an employee's rights by prohibiting an employee from discussing his or her wages, hours, or working conditions, the employee may file a complaint against the employer. If the employer is found to have violated the employee's rights with an overly broad confidentiality agreement, the employer can be required to undo the discipline. For example, reinstate an employee that's been fired and compensate that employee for any financial loss, such as lost wages or lost benefits. What should employers who want to have a confidentiality agreement do? First, if you already have a confidentiality agreement, review the agreement. Make sure the agreement does not unlawfully restrict your employee's rights. If it does, change it and redistribute it to all employees. Second, if you do not have a confidentiality agreement, but are in the process of creating one, make sure the agreement is not overly broad and does not restrict an employee's right to discuss wages, hours, and working conditions. Third, limit access to the company's information that is truly confidential and proprietary. But don't overreach. Remember, if the agreement is overly broad or unlawfully restricts an employee's right to discuss wages, hours, or working conditions, the employer may not be able to enforce that agreement. I'm Judith Sadler, attorney in charge of the Energy Corridor Office at Holmes, Diggs & Eames.